Thank you. My name is Janet Mills. I am the Attorney General of the state of Maine, and I'm pleased to be here. Thank you for inviting me, Congresswoman Royal. And I've practiced law for 38 years, civil and criminal. I was previously the elected district attorney for 3 counties for 15 years. And I'm in my 3rd year as Maine's Attorney General. Also served 6 years previously in Maine legislature. Maine is very proud of being ahead of the curve when it comes to consumer protection laws, when it comes to protection of our natural resources, labor management relations, at least up until recently, and health and safety regulations. As the Chief Legal Officer and the Chief Law Enforcement Officer for our state, I'm troubled by the impact of international treaties which threaten the ability of our states to regulate activities in our jurisdictions and to enforce our duly enacted laws to protect the public interest. Everything we've done for the last 60 years is threatened by certain trade agreements that are negotiated in secret, adopted without amendment, and enforced without fairness. This backdoor bartering is selling states' rights down the drain. It is risking the public safety regulations we've had in place for decades, with the additional risk of losing more American jobs, losing market share, losing business, losing dollars and cents to other countries. Chapter 11 of the North American Free Trade Agreement has become the model for other trade agreements, unfortunately, providing a procedure for investors based in other countries to challenge state laws and regulations. The investor-state dispute settlement procedure you've heard about. And regulations that affect the investor's way of doing business here can be challenged. Even so far as to challenge state court judgments, maybe federal court judgments for all we know, in a way that is wholly unavailable to United States citizens or to businesses based in our country. The U.S. Trade Representative has stated that investor-state arbitration is very important to the negotiation of trade treaties. He claims that arbitration provides investors in foreign countries with such basic legal protections. He assures the public that the United States and its foreign partners will continue to enforce regulations in the public interest. I am not as confident. Recent history makes me suspicious. The Conference of Chief Justices, judges from across the country who rarely dabble in trade policy, are also suspicious. They passed a resolution 2 months ago urging Congress and the U.S. Trade Representative not to allow foreign investors any greater substantive and procedural rights than those the United States citizens and businesses have. Last year, that same group of distinguished jurists was so concerned about the sovereignty of state judicial systems that they passed a resolution asking Congress and the Trade Representative to ensure that trade agreements recognize the right of state courts to regulate the admission and performance of lawyers in their own jurisdictions. Really? How could something so fundamental as the licensing and supervision of attorneys by the states suddenly be of such a concern to our state court judges, the highest court judges in our states? Something is terribly amiss with our globalization agenda. In my own state, our Maine Citizen Trade Policy Commission, which has been in existence for 10 years now, it's a bipartisan commission, they recently looked at the effect of trade agreements on agriculture. Contemplating the proposed Transatlantic Trade Investment Partnership, TTIP, and the proposed Trans-Pacific Partnership, TPP, now being negotiated without public input, as has been mentioned, folks in Maine have expressed deep concerns about our ability to protect food safety regulations, public procurement programs that favor locally grown foods, for instance, geographical indications, or GIs, which brand products such as Maine lobster based on their place of origin and their reputation for quality, and even our state's milk price supports program, which sustains our dairy farmers. All states should share these concerns, and not only for farmers. In a 2012 assessment, our same bipartisan Maine Citizen Trade Policy Commission expressed urgent concerns about the enforcement of our tobacco laws, pharmaceutical pricing and marketing, and general government procurement regulations. Nationally, we attorneys general have led the fight against big tobacco to protect the public health. The Master Tobacco Settlement Agreement of 1998 created new protections regarding marketing tobacco to children and other advertising abuses. We're all familiar with that now. It's become part of our culture. banning tobacco, that Joe Camel and all that kind of thing. We banned it. State and local regulations also target tobacco in licensing, taxation, minimum age for purchasing products, retail display regulations, fire safety standards, minimum prices, and more recently, indoor smoking regulations. All of these important public health protections, I believe, are in jeopardy because of various trade agreements either now in effect or now being negotiated. These concerns are not merely hypothetical. Cigarette manufacturers and individual countries have challenged the Master Settlement Agreement and related laws and bans on tobacco flavoring in NAFTA-sponsored arbitrations, requiring extensive litigation and expenditure of a great deal of state and federal time and resources. These challenges defy the intent and purpose of the Master Settlement Agreement, and they undermine our deep-seated interest in protecting youth from dangerous tobacco products. For that reason, I joined 48 other attorneys general, 48 including myself, I guess, this past January in a letter to urging the U.S. Trade Representative to preserve the historic achievements of the Master Settlement Agreement, as well as the important federal prerogatives of the 2009 Family Smoking Prevention and Tobacco Control Act, which prohibits misleading labeling and advertising, and which gives the FDA broad enforcement and regulatory authority over tobacco products. We are most concerned about the investor-state provisions of trade agreements that are intended to ward off protectionist policies that harm exports and harmonize regulations among the member nations. That's the word they use, that harmonize. I love it. Sounds like a chorus. At the same time, however, these provisions give private industries certain unique and extraordinary avenues to obtain relief from governmental regulations that might affect their profits. These dispute resolution mechanisms are entirely outside the legal systems of the countries involved, and they are conducted under standards that are different from those applied in our courts. We have no say, no control of them. Invoking these arbitration provisions recently, one major drug company contested the ability of a Canadian court to find unlawful and misleading a patent for one of the company's drugs, claiming that the company claimed that the court decision affected the company's bottom line in violation of a multinational trade agreement. It was NAFTA. That matter is still pending, but it serves as a danger signal that these unusual arbitrations could well jeopardize the historic rights and sovereignty of the nations and of the states within them. In today's global economy, it is important that the United States become a good trading partner with the European Union and with Asian countries, and that treaties be forcefully negotiated and respected, with the interests of our national economy in the forefront. These negotiations, however, should be conducted transparently and without risk to the important public health and safety concerns and interests embodied in decades of our state and federal laws. Our citizens expect no less. Thank you.